want to thank all our fellow ambassadors who've been presenting this week, and especially Ambassador Dupree for making this unique opportunity available for the Robert Jackson Center, as well as that unique opportunity available for you to share in this experience. I also want to thank Chautauqua Institution, to Dale McBride, to Bruce Stanton, to Mike Sullivan, and for all of members for setting this up today and making this part of a continuum of Robert H. Jackson Center activities. We're sort of a work in progress. Hopefully all of you had an opportunity to pick up sometime during the last day or so a little bit about Robert H. Jackson through this program called From His Mighty Pen, which in turn set forth specifically all of the little bit of his biography, and which you'll learn more about today. So you learned a little bit about who Robert Jackson was, and perhaps you had a chance to read the biographies of who the participants are. Our first roundtable discussion 2 years ago included participants of the Nuremberg trial with Justice Jackson. They included Whitney Harris, Bernie Meltzer, James Conway, and Henry King. Last year we had the opportunity to have a similar roundtable among the clerks of Justice Jackson during the 1940s. It was a very enlightening day, and I'm sure this will rise to that same level. Today's program, maybe just a little bit of housekeeping. We will be taping this now through noon. We asked if you have any questions, you keep them to yourself. We're sort of, at this point, pretend you're sitting and watching a little conversation in a living room. We will then all go to lunch. And during that lunch period, there'll be an opportunity which we'll make available to all of you who have questions for these folks to answer them during the lunch period. And I know you have classes at 2 o'clock. Later tonight, the dinner, we're combining the Robert Jackson Center dinner honoring these clerks together with your dinner for a special evening, which there'll be special program distributed at that time. Also like to introduce a couple of Robert Jackson relatives. Tom Loftus and Julia Craighill came from Washington, D.C. today to be part of this. And they're the grandchildren of Justice Jackson. And Tom and Julia, wherever you are, if you could stand quickly so we could recognize you. They're right here. Without any further ado, since you don't want to hear me, you want to hear the clerks, let me introduce Professor John Q. Barrett, who will be moderating the event. Professor Barrett is a professor of law at St. John's University in New York City, where he teaches constitutional law and legal history. He's also the Jackson Center's Elizabeth S. Linné Fellow. He's been an integral part from the get-go regarding making sure that we're on a scholastic right plane at the Robert Jackson Center, and we're eternally grateful to Professor Barrett. Most immediately, Professor Barrett found and edited and introduced this book authored by Robert Jackson called That Man, an Insider's Portrait of Franklin Roosevelt, which has received rave reviews from the New York Times, Washington Post, Wall Street Journal, et cetera, et cetera. We're just so proud to have John be part of the Robert Jackson Center, and so proud of the fact that Professor Barrett will be leading this unique opportunity to listen to the clerks of the 1950s. John, it's all yours.
Good morning and welcome to this roundtable discussion. Let me begin by giving you a quick thumbnail of Robert H. Jackson. Who is this person who became the employer of these young lawyers who became law clerks? Robert Jackson was born in 1892 in Spring Creek, Pennsylvania, just below the New York state line, on his family farm. He, as a young boy, moved across the state line into New York State and grew up in the small town of Frewsburg, where he attended the small public school, graduating as a senior when he was 17 years old. He then spent one postgraduate year taking the trolley north to this nearby city of Jamestown and matriculating as a postgraduate student at Jamestown High School. And that was the end of his higher education as a general matter. He never attended college. After that 1 year of advanced literature, history, some economics, and some special mentors at Jamestown High School, he spent 1 year as an apprentice in a local law office, a next year as a student at the Albany Law School, which was his only year of legal schooling, and then a third year back as an apprentice in a Jamestown law office, all of which completes his education and training by age 21, which is when he took and passed the New York bar exam and began to practice in this region and briefly in Buffalo. Over a 20-year span, Robert Jackson became an extremely successful, a very accomplished, a very well-regarded lawyer in this city, in this region, in this half of the New York State, and in bar association circles nationally. He also became involved in Democratic politics, and over that 20-year period had a deepening connection with Franklin Roosevelt. As Franklin Roosevelt's trajectory took him to the White House in 1933, the call soon came to Robert Jackson for him to go to Washington and join the New Deal. And so beginning in 1934, Jackson is in the Roosevelt administration and ascending to ever more significant positions. His first job is as general counsel in today's Internal Revenue Service. He then moves to the Justice Department, where he is the Assistant Attorney General heading the Tax Division and then the Antitrust Division. He then becomes Solicitor General of the United States in 1938, representing the United States government before the Supreme Court of the United States and performing as one of the finest Supreme Court advocates in our nation's history. In 1940, he's appointed and confirmed as the Attorney General of the United States, and for an 18-month period, in a time of great pre-war complexity and real homeland security issues, he is the nation's chief law enforcement officer. In the summer of 1941, President Roosevelt appointed Jackson to the Supreme Court, and he served on the court for the remaining 13 years of his too short life, with a one-year hiatus. In 1945-1946, Jackson was away from the court by assignment of President Truman to be the chief American prosecutor at Nuremberg, Germany, of the 22 principal surviving Nazi leaders. Robert Jackson died at age 62 in 1954, and he's buried in the country cemetery in Frewsburg within blocks of his boyhood home. As a Supreme Court justice beginning in 1941, Justice Jackson was an employer. Each Supreme Court justice, then and now, employs one or more young lawyers to be a law clerk. A law clerk is an inside the justice's chambers assistant. It's an elite position. They're extremely well-qualified, brilliant young attorneys who get these clerkships then and now. And in that year or two of clerking experience, a clerk is on the inside of his or her justice's work as a member of our nation's high court. Robert Jackson, over his 13 years on the court, had 11 law clerks who worked sometimes solo, sometimes as part of a pair, sometimes for a year, sometimes for 2 years, in one case, which we'll talk about later, for a year and a half, spanning 2 years in the life of the court. As one piece of vocabulary, the Supreme Court's work is structured in terms. The term of the court is named after the month in which it convenes, October. And so when we talk about the October term, for instance, 1950, we're talking about the 1950-51 calendar year in the life of the Supreme Court. We're very privileged to have with us today 3 lawyers who were Jackson's law clerks during his final years on the court. I'd like to introduce on my immediate left George Niebank, who was with Jackson as a law clerk during the 1950 and 51 terms of the court. George Niebank is a native of this region, a graduate of Yale College, of the University of Buffalo Law School, and following his Jackson clerkship, a very accomplished attorney in a variety of positions and locations in the country, really, but for the bulk of his career, the senior counsel for the Atchison, Topeka, and Santa Fe Railroad, which he'll tell you, despite the song, never went to Philadelphia. George, welcome.
That's right.
Next, chronologically, across from me is Donald Cronson. Donald Cronson was Jackson's law clerk during the 1952 term of the court, the 52-53 year. Don Cronson is a native of Chicago. He was a graduate of the University of Chicago. I should have mentioned in George's case, and it's true of each of these gentlemen, they all served our country during World War II. Following his military service, Don Cronson completed his education at Chicago and then went into practice. After experience both in private practice and as a federal prosecutor, he became Jackson's law clerk. And following his year with Jackson, he returned to private practice, first in New York, and then in a global capacity, crossing the Atlantic, where he practiced in Switzerland, in England, again in Switzerland, where he is still today a resident. He's made an extraordinary journey to be with us today. Don, thank you for being here. Our third law clerk, in the middle of the trio to my left, is E. Barrett Prettyman, Jr. Barrett Prettyman, a native of Washington, D.C., was Jackson's final law clerk during the 1953 and 1954 terms of the court. Barrett Prettyman is a graduate of Yale and of the University of Virginia Law School. And following his Jackson clerkship, he has practiced law both in the government, including in the Robert Kennedy Department of Justice during the John Kennedy administration, in private practice with the law firm of Hogan and Hartson, where he is of counsel today, in the District of Columbia government, and we're very pleased to have Barrett Prettyman here with us. Thank you. I'd like to begin by asking you to talk about being a law clerk, how you came to be one, what Robert Jackson was looking for among all the fine young lawyers in the country as he picked you out of the pack to be one, and what the job was about as you were getting started. George, tell me about being a law clerk.
Well, as you remarked before, I grew up in Jamestown. I was not born here, but I grew up. And I knew Robert Jackson as a boy, and later on, mostly through my father. My father and Justice Jackson were very close. Now, when I went to the University of Buffalo Law School, it was contemplated that I would come back to Jamestown to practice. But Justice Jackson kept track of my progress through law school, where I managed a credible record, and in the course of his recommendation to the Illinois Bar, he notes that he invited me to be his law clerk. And of course, that's the kind of invitation you don't decline. And he had remarked to me before I actually started that the work may be a little disillusioning after a while. And when I got there, I was much younger. You know, you get kind of loose about things. Say, well, here I am. It's great, but it was awesome at first. But that soon wears off when you realize that you've got 9 human beings doing a job, and each office operates more or less according to its own rules or customs. And that was certainly true in his office, where we examined the petitions for review by the court, including what they refer to as jurisdictional statements. And those came in at the rate of about 30, 35 a week. I understand the volume is much heavier now. But as those came in, and they would come in from the clerk's office in gurneys, we would start to and review them all. And we had a rule of thumb in Justice Jackson's office that, except under the most unusual circumstances, you don't write more than 1 typewritten page. Now, I'm sorry for some of you lawyers who file these voluminous briefs think that your case gets reduced to 1 typewritten page, but that's pretty much the way it was. Now,
or less.
Or less. Well, often considerably less. And you get the notion of clerks getting together with the justice to review these things. Now, I don't know about Don and Barrett, but I don't recall ever reviewing a petition for certiorari or jurisdictional statement with them before the court's conference. Did you?
One case, which I'll mention.
See,
later.
so normally he had confidence in us, and we would prepare these memoranda. He would review them, and generally I think he agreed. And he'd go off to the conference and come back, and then often more often than not, would be no interchange about that sort of thing.
Let me turn to Don. Unlike George, who really had his eye on Robert Jackson from his boyhood, and Jackson similarly on George, you had, I think, an eye on Jackson long before he'd ever heard of you. How did you come to be a Jackson law clerk?
At the end of my studies at law school, the dean of the law school recommended me and 2 other people as potential law clerks for the Supreme Court. And I, at that stage, already said I'm only interested in working for one justice. And I think he perhaps mentioned that at the time of his recommendation. But at that time, I was not accepted. I think it was at a period when he had a clerk who was going to stay for a second year, and there just was no vacancy. But I had, during the course, particularly during the latter part of my studies, after I had been in the Army for 4 years, I had really kind of sort of fallen in love with the things that Jackson wrote, and I had become well acquainted with just about everything that he had written. For various reasons, about 2 or 3 years later, I got to a hiatus in my professional life. So I wrote a letter and said, if you have a vacancy for a law clerk, I'd be interested. And strangely enough, I got the invitation to come in and see him. I remember a short conversation I had at that time. He invited me into the office and he said, I understand that you are interested in engaging in the work of this court. And I said, no, sir, I'm interested in engaging in the work of this justice. And he then assured me that at least as far as his chambers were concerned, most of the work that would be done within the framework of his chambers. There would be some work with some of the other justices and some of the other law clerks, but it was mainly a one-judge proposition, which was fine. I was not then offered the position sur le champ, but very shortly thereafter he called me in again, and he did offer me this position. And although this was many years ago, I can remember some very interesting things about that conversation when I was told what my duties were going to be. Because he said something like this: in my young days as a lawyer, I interviewed the client, I selected the facts, I did the legal research, I prepared the pleadings, I did the briefs, I presented the case, I presented the briefs on appeal, I argued the appeal, I did everything. And that has always been my principal method of operating, and at least when I was Attorney General, people used to worry about that because of the fact that I always would take a large area of activity and do it all myself and only loosely survey all the other things that were going on. And particularly in this office, that's the way it's going to work. My particular responsibility are the opinions. I'll be glad to have your help on it from time to time, but they're my opinions, they're not yours. You're the guy, it's you and Bill are going to do the petitions for certiorari. Now, I will review what you do on the petitions of the certiorari, but they're your principal responsibility. But be sure that I expect you to do a very thorough job on that, and don't just examine the petition and the papers. I expect you to read the record and even, if necessary, come up with things which aren't presented by counsel.
Okay. Barrett, same general question to you. Your childhood in Washington, D.C. Gave you a proximity to Jackson and the administration that he was a part of. Your father was a New Deal lawyer and then in private practice in Washington, acquainted with Jackson, and you had some dealings with Jackson during your time as a law student. Tell us about the path that brought you to the clerkship.
Jackson succeeded my father as general counsel of Internal Revenue, and they got to know each other then and became quite good friends, and they would go to social events together occasionally. So when I was in law school, I was a member of the legal forum, which brought speakers down, and I asked the justice to come down to speak to the law school. And he did come down, and he expected events all through the afternoon and evening. And he looked kind of tired, and I said, well, now, your job for the afternoon is to go to sleep. And he went off to his room and slept all afternoon, and then we had the cocktail party, and he spoke, and he seemed tremendously grateful for that. In any event, several years later, after I had graduated, I applied for this clerkship, and he had me in, and we had a nice talk, and we talked about everything, politics and the law and so forth. I had sent him my note from the Virginia Law Review. And he ended the conversation by saying, I'm not going to have two clerks. I'm only going to have one clerk. He said, if you will take the job under those circumstances, you can have it. It took me about, I'd say, maybe 5 seconds to accept that. And I became his only clerk for that year, and then he asked me to stay over for a second year, and he died in October of the next term before that year was completed. So I ended up writing over 3,000 memos on the cert petitions that were filed, and you could usually tell it wasn't that the two of you were in agreement, it was that you, the law clerk, knew the thinking of the justice and knew what he was going to do. So you could usually tell which ones he might vote to grant a hearing on, grant certiorari, and the ones that he wouldn't. The one exception, George, I'd take just a moment to tell you, he came in one day to my office, he slammed my memo down on the desk, he said, this is an outrage. And I thought for a minute he meant my memo, and I was extremely nervous, and he said, this case is an outrage. Now, at that time, we had, and I assume they still have, what we called a dead list. That is a list of cases that were not even going to be discussed by the justices at conference because they were so uncert-worthy, meaning that they were not worthy of taking and having a hearing on. Any justice could take a case off of the dead list. This case was on the dead list, and Jackson instructed me to take the necessary steps to get it off of the dead list so that they would discuss it. Very briefly, it was a case where a ship was out at sea, but not that far from land, and caught fire on deck. And the captain took one look at this fire and said, every man for himself, and jumped overboard. And everybody on deck jumped overboard too and started swimming for shore, and they were picked up by boats and so forth. Well, the people below deck, the crew below deck, didn't even know that there was a fire. And finally they came up on deck, and the wind had changed, the fire had died down. They put the fire out, and by the time the fireboats were coming back to the ship, they had claimed the ship. They claimed it as their own. And they said the captain had deserted, and it's our ship. Well, the courts did not give them the ship, but Justice Jackson wanted to give them that ship, and the case came up at the conference, and of course they all voted except for him not to hear the case. And I never knew what got into him, whether he had some incident in the bathtub when he was a kid or something. I never knew what got him so excited about that.
Well, actually, I don't know if this is the association or not, but George, your early memories include Jackson on a boat.
Yes.
Can you connect it to this case, or in general, tell us about the alibi?
Well, the alibi was a boat which he kept here at a dilapidated old boathouse towards Celeron, and it was his, as the name implies, alibi to get away. You go down there and go out and usually take local businessmen, including my father, and they'd go out and cruise up and down the lake and have refreshments. And my father was very good. He used to take me all kinds of places with him, including to go to those. And so while the men were all up front doing what they were doing, I'd sit on the back on the stern of the boat in a wicker chair and watch Lake Chautauqua roll by. But he used the alibi quite a good deal. It was an old boat. It was not commodious, but it was well kept and well appointed. But if you could have seen the boathouse he kept it in, it was unbelievable. But it was a lot of fun. And he enjoyed the alibi, and I don't know what became of her.
Today should be a collector's item, I think. I don't know
Well,
if she still exists
I
somewhere.
have the sneaking suspicion that she no longer exists.
Probably right. Let's,
Well, whether or not for that reason, he did have an abiding interest in matters of maritime law.
elaborate.
We did have a couple of cases while I was there. Lawrence against Larson, which is a fairly well-known case involving extended jurisdiction over foreign claimants under U.S. law. And he used that as an excuse to ask me to do a very detailed study concerning the extent to which the U.S. exercises jurisdiction on both American and non-American vessels around the world. We also had a couple of cases which interested him a great deal involving the application of the National Labor Relations Act to vessels. There were some others too which I can't particularly remember at the time, but I know that every time there was a maritime aspect, and also every time that there was a conflict of laws aspect to a case, it automatically invited his particular attention.
Let's develop him a little bit, particularly at the time each of you comes to be a law clerk. He's someone who had been in the Roosevelt cabinet, had been on the court for approximately a decade. When your clerkships began, he had been the chief American prosecutor at Nuremberg. He's a world figure, a very famous attorney. In the pantheon, how did you rank him in your mind? What was your appreciation for what he stood for, and what was he like as a man, as a person, in this informal personal capacity in which you got to know him?
Well, the easiest is the last. There's never been a more pleasant person to work with in this world than Robert Jackson.
He was a man of contradiction. I loved the man, and he was affable. He was very funny. He was outgoing in so many respects, and on the other hand, he was a private person. I wrote an article about him as Solicitor General, and I interviewed all the people then alive who had worked with him in the Solicitor General's office, and they all said, and this follows up what you said, Don, that they never knew until the argument what he was going to talk about, because he never had a moot court, he never consulted with them, he did his own thing. And I was lucky being an only clerk, because he would often come in and just put his feet up and talk about whatever seemed to be the headlines at the time and so forth. And then, of course, talk seriously about legal matters too. But he did not, he was not one of those, like Frankfurter and like Harlan, as a matter of fact, who wanted to talk out the case in legal terms in order to see where he stood. Often a justice will use his law clerk in that manner, not so much to get the law clerk's ideas. This kid out of law school is not going to show him the way, but rather by talking something through, you get a better grip on the case. You get a feeling. You see some sides of it that perhaps you hadn't occurred to you, and better prepare for oral argument and, of course, for the conference. So. I found it amazing that he could be so affable and humorous on the one hand, and yet keep a part of himself apart and private.
George?
Yeah, I second what Barrett says about his private times. You'd have a spell of 2 or 3 days in the office where you really didn't see or hear much from him. And those were apparently his private times, thinking whatever he was thinking. But I had an enormous amount of respect, and as it turned out, affection for the man. Respect for what he'd done and the way he did things. It was a magnificent experience.
And you know, when you imagine that this man was essentially self-taught, as you have explained, he had very little formal education, but he read everything, and he wrote beautifully. However, in his writing, he would sometimes make small mistakes that you as a clerk would come along and correct. The mistakes of somebody who didn't have that formal education, but who nevertheless had read far more than you could ever expect to read in your own life. He just had a wonderful imagination, and he was also a very practical man. The experience that he had here in Jamestown as a lawyer, he knew all aspects of the law. He knew how to practice. He knew how things went. And so often there was that, it shows up in his opinion, the practical view of life, not
Yes.
some esoteric, theoretical, academic view of what the law might be, but rather what does this mean in somebody's real life and how you take care of this problem.
Related to that, one of his continuing concerns always was thinking of the Chautauqua County type lawyer. What is he going to do when he gets this opinion? And there were times when the court would rely at great lengths on legislative history, you know, Senate reports, House reports, the Library of the Congressional Record. And you know, I don't think you can find a whole lot of that in Chautauqua County. So, it was a concern of his, a very lively concern. But at the same time, it did not keep him from using legislative history when it served his purpose.
John, could I would you indulge me to read one paragraph
Of course.
from an opinion? that
Any
I
of
think
his writing is
touching on what we're talking about. This was a concurring opinion of his alone in a case called Adams versus Merrill. I'll just read one paragraph. The only controlling fact for me is that this act is on the federal statute books. What someone intended almost a century ago when it was passed, or in the 1890s when Councilman versus Hitchcock was decided, I do not know. Since the last event, some 30 Congresses have come and gone. Something near 15,000 congressmen have been elected, not allowing for re-election. How many of them knew of Councilman versus Hitchcock? How many felt frustrated by it? And how many would have vented their frustration by repeal? I do not know or care. Congress left the act on the books, and it was there when this petitioner testified. The only question is what it would mean to a reasonably well-informed lawyer reading it. That is really quintessential.
You find
Jackson.
that often in his opinions. That's the thing.
I mean, the contradictions or the dual character are present in the biography. He is, of course, Mr. Justice Jackson and the Nuremberg prosecutor and an international figure at the time you meet him, but he also refers to himself as a country lawyer, a Jamestown lawyer, a self-taught man. And what I'm hearing is that that's not just a shtick. That's really how he thought of himself.
Yeah, that's right.
Let me ask about his work process, and then we'll connect it to your own as a law clerk. But how did he do his job as a justice? How did an opinion come to appear at the end of the process for Robert Jackson?
Let me save it. Rather quickly, we would get a first draft, and you wouldn't recognize the first draft as typical Jackson writing. That magnificent style of his was the result of very hard work, and he did several rewrites. He always was glad to get suggestions from his law clerks from the time of the original draft, but it was a matter of a great deal of work to turn out those beautiful things.
Yeah, he would be engaged in the cert process only by way of the memos, as George has said.
The cert process is the decision of which cases
As
to
to
take.
which cases to hear. And you understand that they only, in those days, they were only hearing about 150, 60, 70 cases a year. Now they're only hearing 80-some, so they cut that in half. But out of those 3,000 cases, people asking to be heard, they are only taking 150 of those. So on that part of the process, he would simply decide, usually on the basis of your memo, and at the end of the memo, you would make a recommendation, grant, deny, and then he would check off on that.
He sometimes disagreed.
Sometimes he disagreed. That's absolutely true. And then, in terms of the writing is concerned, as Don says, he virtually always wrote a first draft himself. I did have the experience once, Don, where he let me, in a very mundane tax case, he let me write the first draft, and I'm sure he did this just to be nice. He let it stand. I had these footnotes with hundreds of cases cited, and I guess he felt sorry for all the work I'd done. And he didn't change it. So I won't tell you which opinion, but I do have an opinion in U.S. reports.
Shouldn't be hard to find that tax case with the hundreds of citations in the footnotes.
And then, excuse me, but after argument, he would sometimes, but not always, have a little discussion, and it might be more about the person who argued in the advocacy than it would be about the case itself. And then after they had their conferences, where they would vote on what to do with the case, quite often he would round that up for me and tell me what, and particularly indicate which cases had been assigned to him. So you had some flow back and forth of a personal, social nature and some of a professional nature, but as George says, sometime you wouldn't see him for a while.
I think it's worth adding that it was quite rare for him to ask a law clerk to do legal research. He had in his head every single decision in the United States reports from volume 300 on. He knew the case, he knew the name of the case, the parties that conclude what the case held, what the dissent held, what volume it was. He didn't always remember the page number, so sometimes he'd have to reach up and pull down the book and get the page number. We did have, I did have occasion to do some legal research. For example, there was one case where there were many questions of New York law, and he almost apologized to me. He said, you know, you're a New York lawyer, but I haven't practiced law in so long in New York that I've forgotten a lot of this stuff, so would you please look up these points? But it was rare. Okay. He was our principal legal researcher.
Okay. George, well, what's your recollection of his work
My
style?
recollection, frankly, is quite different from Don's, evidently, because at least in our day, the conference, there'd be a conference after the arguments, and in due course, it usually was on a Friday, the Chief Justice sent around an assignment list of who was to do what. Well, we'd see which cases Justice Jackson was going to, had been assigned to him, and then, frankly, we'd wait. And what normally happened was that he would take a yellow pad like you have there, and he would write his first draft out in longhand. He'd give it to his secretary to type, and then we'd get a copy of it. Now, in the course of that, he would mark the places at which he expected to have citations or footnotes. And on occasion, he would even give you a lead as to where these were. But what we did was he left it, he knew what the law was, generally, was that it was up to us to find the precise authorities to support it. And we wound up writing most of the footnotes after the research. Now, I told you that he generally knew what the law is, and that's right. But I can think of two instances in which it was not right. One, after I'd left the court, and I was working in a labor matter with the railway, he was in town visiting and came by, and we were walking down the street on Michigan Avenue for lunch, and he said, now what are you doing? I told him it was a labor matter involving the right to work without belonging to a union. No compulsory union membership. I said, well, you know, there is a constitutional right to join a union. He said, who said so? I said, well, among others, you. in one of the Jones and Laughlin cases. Oh, he said I did. Yes, you did. But we went on and talked some more, and I don't remember what the rest of the conversation was like. On another occasion, and this was, he had felt very strongly about this, and so he had written this all out, and it was typed up and went through, I guess I was alone at that time, through me, and it related to the legislative history again. And he said, you know, I have always assumed that when the Constitution required a bill to be read 2 times before it was enacted, that those who heard it would know what was going on. Well, it made the circuit of the entire court, all the clerks, all the justices, and was handed down on, in those days, all opinions came down on Monday. It was handed down on Monday, and by golly, starting Tuesday, we started getting the telegrams. Remember, one of the first ones was from Professor Paul Freund at Harvard, saying, Mr. Justice, would you tell us where in the Constitution it calls to read kills twice? And it doesn't. So we thought the opinion was still in not draft form, but what they call a slip opinion. So we were able to get back to the printer and get that corrected.
That's very funny. Let me ask about the oral argument process. Jackson himself had argued dozens of cases before the court. Barrett Prettyman, you've argued many cases before the court. George, I know you've argued. Don, you've been in courts also. When Jackson was on the bench, how did he treat the advocates? What was his approach to oral argument as a justice?
Well, he was kind but sturdy. He would ask the tough questions, but never in a threatening manner or in a put-down fashion, as has been done by some. It was never a fight, but he had a point of view, and you would certainly hear from him. And sometimes there would be humor mixed in the question. It was not uncommon to have the audience laugh after a Jackson question, not at him, but because there was an element of humor in the question. He was not as active a questioner as, say, Frankfurter, but he was not shy either.
George, do you?
Well, my recollection was that he was very fair to counsel. And if the man, sometimes woman, is falling short in the argument, he wouldn't jump on him or her, unlike somebody else we can think of. And he just sort of pulled back out of the thing and then took care of it when we wrote the opinion.
Would argument change his mind or affect his thinking about a case, or not very much?
I doubt that it changed his mind in the result very often, because he was pretty well informed when he came on the bench. But I know of instances where, and I can't drag them up now, but I know of instances where they changed his view of perhaps how the opinion should be written or where the emphasis should be, or he may have gone in thinking that a particular point was vital when in fact it turned out to be not that important. Things of that sort. It shifted the emphasis, I think, occasionally, but I would guess that there were very seldom did he actually change his mind between pre-argument and post-argument.
I can think of a case where he changed his mind because of arguments with Bill Rehnquist.
Okay.
After the argument.
Okay.
We haven't mentioned that Don was co-clerk with Bill Rehnquist.
As was George, and I will ask about the Chief Justice in a little bit. Before we get there, let me ask about some cases, significant decisions from each of your tenures as a law clerk. George, one matter that the court handled was the Steele seizure case.
Yes, that was very important. And to be perfectly frank, I used to have a complete set of the briefs. I do not have as sharp a recollection of the procedure as the current Chief Justice does. I have my recollection is that the decision,
Well, excuse my interruption. Let's step back and just set the factual setting. President Truman
oh, well, I'm
seized
sorry, I
the
thought
nation's steel mills in the spring of 1952.
in the face of a threat by the steelworkers to strike,
Okay.
and this was at the time of the Korean War, and they felt that there was, we could not stop the flow of steel, and undertook to write an executive order directing that the steel mills be seized, and that the present managers continue to manage them, but on the account and effect of the government.
Right. So the legal issue, maybe to overgeneralize it, is whether a president has an inherent power to do what he believes needs to be done in a wartime situation.
In those situations, right. And the feeling, as far as I could tell at the time, generally was negative, that he couldn't do it. But the thing went in such a blur, from the issuance of the executive order to the, I don't remember, presumably it had a district court hearing, then to the Court of Appeals for the District of Columbia, and then in nothing flat up to the Supreme Court. And it was a very fascinating time, very exciting.
Now, President Truman lost that case, and Justice Jackson wrote a concurring opinion that's really come to be understood as
Right.
as the holding of the case. Tell us a little bit of the backstory about Truman and the court in that deciding and in the aftermath. How did Truman think of the court's rejection of his claim of power?
I can't directly respond to that, but I can respond very indirectly.
Okay.
It was the habit of Justice Black to have the court to his home in Alexandria after the court term for dinner. And at this time of the dinner, the invitations were shortly after the Seizure case. And of course it came up, and I don't think Harry Truman was particularly pleased, but he remarked that, I almost came up to argue that case myself. And Justice Douglas clapped him on the knee and said, well, why didn't you? That would have been something.
Don, let me ask you about a memorable case. The Morissette case it's an interesting fact pattern and a kind of, I think, an example of common sense judging by Robert Jackson. Tell us about that case.
You'll have to, the name doesn't ring a bell at the moment.
Oh, I'm sorry, George, is that your case?
Yes.
My mistake on the chronology. Go ahead on Morissette, and then I will come to you about Brown.
Okay. Morissette is from a case from Michigan. This fellow living in a small town up there was near an army operation of some sort where they practiced artillery firing. And within plain view of the road, there was a great big pile of this size brass shell casings. Brass, especially then and even now, is worthwhile. So Morissette drove by that a number of times, and he concluded, well, I'm not going to let it just sit there. I mean, if the government's going to discard it, I'll go in. And so he took it. And being that people thought a thief, he took it home and piled it up in his front yard. Well, when the question of intent, what his intent was in this situation, and what was called for under the statute, precise terms of which I can't tell you now, the trial judge had charged the jury. He intended to take it. He took it. That's all there is to the intent. And the court was all set to let him go to jail until we backed off and take a look at it. My God, you can't do this. They've got to think what was in that man's mind. And so thereon, he, as a result of that opinion caused Justice Jackson, in my relationship with him, to call down more books from the library than any other. I mean, it's the kind of thing he liked to get into. And of course, they, to Morissette's great relief, they set aside his conviction.
That's good. Donald, let me ask you about the Brown versus Board of Education case, which came to the court, didn't get decided, but came to the court and was first argued during your term as a law clerk.
Right.
What's your memory of that case?
First, I should explain that this was the case as to whether or not the Constitution prohibited so-called separate and equal educational facilities. There had been a decision about 50 years before involving railroads where that had been held that was perfectly constitutional, and the question was whether or not that prior decision should have been overruled. It was talked about a great deal among all the law clerks. It was considered the big case coming up for that term of court. And it was one of those relatively rare cases where Justice Jackson did discuss the case prior to the argument with his law clerks. I, to this day, have a pretty good recollection of a lot of what was said, because my recollection was very much stimulated. The problem came up 30 years ago when Justice Rehnquist was first nominated for the court, and I had quite a good recollection there, and I think a lot of
He was
still,
your co-clerk
the co-clerk,
at the
yes.
time.
Yeah. But I still remain fairly convinced that he did indicate to both of us that he was afraid that the court was on the path to overrule Plessy against Ferguson, the precedent. That he had a lot of misgivings about it. First of all, he really wasn't all that persuaded that Plessy was wrong. And secondly, something you find very often in Jackson's positions, a great reluctance to overrule constitutional precedent, particularly when institutions have grown up around it. And this I distinctly remember. He told us that Justice Black had told him that if the court outruled segregation, the southern states would fight. Those were he quoted the exact words.
Justice Black being from Alabama.
From Alabama, right. It is interesting to note that by that time, Black and Jackson were very close friends. They had been rather bitter enemies not too many years before, but by then their chambers would join one another. They were constantly visiting one another, and this impressed Jackson quite a bit. As a result of those conversations, Bill and I wrote a couple of memoranda for his use at the conference, and I was actually present during the argument. And I do remember that during the argument, Thurgood Marshall, who represented the plaintiffs, was trying to make the point that under the Constitution, it was unlawful for legislation to have any kind of special treatment of any group because of their skin color. So Justice Jackson rather naively said, how are you going to justify all of the legislation in the books dealing with Indians? And poor old Thurgood Marshall never was able to come up with a good answer for that. Mm-hmm. And in fact, he kind of retreated a little bit on that position in the meantime. The evening of the conference, the law clerks were having a party.
This is the meeting of the justices to vote privately.
Right.
On
Not
the
the
case.
argument, but the conference after the argument. And so I took it on my own initiative to go to Justice Jackson and tell him that we were having a party, and therefore it would be rather unwise after the conference to come in and discuss it with the clerks, because there would be a fair amount of alcohol flowing around, and it might be a good thing to keep us in the dark for a while. And I don't know if it was my advice, but he certainly did follow that. He did not discuss that case with either me, nor, so I'm told, with Rehnquist at any time after the argument. The first that we heard about it was on the last day of the term, when it had been announced that it was set over for the following term.
For re-argument.
For re-argument, yes.
Right.
Now, I did see, one other thing I can add here before we get to Barrett's knowledge on the thing. What I now have is just hearsay, but I saw on the French television about 10 years ago a documentary that had obviously been made originally in English but dubbed in French about the Brown case. And according to that documentary, one of the principal reasons that they decided to set the case over was that Jackson had threatened to dissent, and they didn't want to face the threat of a Jackson dissent, and that was one of the main reasons why they decided to set it over for a re-argument the following year.
Okay, now, let's pick up the story chronologically. Your clerkship and
I know no further beyond that point.
William Rehnquist's clerkship concludes in that spring of 1953,
Right.
summer of 1953. Barrett Prettyman alone is the successor, and that case is then re-argued in the following term, what turns out to be Jackson's last full term on the court. Tell us about the re-argument process and what you recall of that.
Yes, it was obviously very much on everyone's mind at the time that I became his clerk. I'm going to talk tonight about Jackson and Brown, so I won't give any detail now except to say I was at the argument, and it was quite dramatic, and it had resulted years later. George Stevens, the son of the great director, was doing a documentary on Brown, and Burt Lancaster was going to play John W. Davis, and Sidney Poitier was playing Thurgood Marshall. And George asked me to come down to Florida, where they had reconstructed the Supreme Court courtroom, and teach the two of them how you argue before the Supreme Court, where you stand and where you have what kind of notes you have and where you put your hands and how you argue and answer questions and so forth. I just had a wonderful time with those two, both of whom were gentlemen and very interesting fellows. So that was a nice aspect of the Brown argument. But after that, as I will go into a little more detail tonight, Jackson had a heart attack, was in the hospital when the Chief Justice brought the opinion around, and subsequently Jackson, against his doctor's advice, got out of the hospital and came to the courthouse on the day of the Brown decision, so that there would be the appearance of unanimity, the entire court sitting at the time that the decision was rendered.
Let me ask about more than the legal dimension before we leave this area, because the legal problem of the meaning of the 14th Amendment and how it applies to school segregation is one level of this. Talk about Robert Jackson in terms of segregation as a social issue. Did he have views? Did he share them with you as a general matter?
Segregation was not an issue during my service. I mean, there were several petitions for certiorari which raised the issue, but they didn't get very far. So he and I never had occasion to get into it.
Okay.
He was very frank a number of times, both orally and in writing, in emphasizing that he came from a situation that was very different than it was both in, say, Cleveland and in the South. Namely, there were not that many blacks in the area that he lived in, and he did not face any of the problems that seemed to be on the minds of many in the South. He did not pretend to know personally the kinds of tensions that might exist.
Okay. That's a good wrap-up. Let's talk briefly about William Rehnquist. Each of you knows him. Two of you worked with him as young lawyers. He was one of the 11 Jackson law clerks, obviously, and that credential played a role in his appointment first as an associate justice and then later to be Chief Justice of the United States. What was he like as a young lawyer and a new law clerk, joining you in that chamber?
His first experience in the court was with me, and well, Justice Jackson. But I knew he was coming, didn't know much about him, But on the appointed day, he showed up, and he's a very affable young man, and I knew then from his record that he was very bright, and subsequently found out with experience that he's even brighter than I thought he was. But he had his taste in ties and socks left a good deal to be desired. But he
Still do.
Pardon?
Still do.
He and I got along very, very well. We are good friends to this day. I used to call on him in his office in Phoenix and find out what was going on out there. And I knew his wife, Nan, very well. And I saw, after I left Washington, I saw Bill quite often. But he was given to taking positions that would sort of more than pique the interest of the other clerks. He liked to bait them. And he would come out with some outrageous stuff. He had I think I mentioned he had a marvelous sense of humor and still does. But he takes some of these other positions, and you realize that essentially Bill and I were the only conservatives in the court. Then everybody else, he'd just drive them right up the wall. These things.
Don, let's pick up with you. He's an experienced clerk when you arrived to join him.
A great deal of what George said, I would iterate. And that same tendency to be provocative, which he enjoyed very much. He got along personally with everybody, but at the same time, he would advance an awful lot of positions, which I think he often didn't even agree himself, but just for the purpose of he loved a good argument. We got to be very close friends during the course of the thing, and we worked closely together on a lot of things. Remember, the big event of the day, of course, was always at lunch, when the so-called Court of Clerks, when we would all get together, and they had some fascinating discussions there, of which Rehnquist often had a very leading role. Still remember the one day the two of us walked in together, and we were both very tall. We were both of Swedish descent, and one of the other clerks saw us come in together, and he said, "There they come, the tall gentleman of Swedish extraction and the big dumb Swede." They never said which was which.
But you knew.
Now, Barrett, you took the handoff from young William Rehnquist. Perhaps you'll succeed him as Chief Justice. Do you have recollections of
Better
him?
do it pretty quickly.
Do you have recollections of him from that time period?
No, not that much, because we overlapped, maybe a week at the most. I did meet him, and I think we talked a little bit about the duties, but it's only been in the years since then. I've argued before him a number of times, and I'm Vice President of the Supreme Court Historical Society, and we have functions up there all the time. And I'm also chair of the Supreme Court Fellows Commission, and have been for 3 prior years. So there are all kinds of events where I see the Chief Justice, and we always speak and so forth. But I've not been I don't see him in his home or our home or anything of that sort. I'm not that close to him.
I'm curious, for each of you and the Court of Clerks, the group of clerks, working there as law clerks, is this the sense that you're all destined to be justices someday, and this is a warm-up act, or is it in fact inconceivable and a miracle that someone like Rehnquist actually does later in life come back as a justice? Did you think about that in your 20s?
Nope.
I didn't.
Absolutely not.
Okay.
Unthinkable.
Unthinkable. Okay. Let's turn back to Jackson. I'm wondering if he would have made comments to any of you about some of the landmark decisions that he wrote earlier in his time on the court. For example, the Korematsu Japanese-American internment case where he wrote one of the 3 dissenting opinions.
That one, yes, that one I think was one of the cases in which he was most proud. I can't remember I'm sure he probably talked about others too, but it's just that it's been 50 years and my recollection is not as good as it should be.
Okay.
But I do remember it.
I think we should tell them that involved the internment on the west coast of Japanese Americans during World War II.
Okay, thank you.
Mandatory internment.
Do you recall him commenting back on that case or that episode?
I can
I have no
remember
recollection of such a comment at all.
Okay.
I do remember a comment which relates to the Karamazov case and several other cases that came up in which he made often. And I think that Barrett probably, and George will probably bear me out, the same thing. That is, he frequently commented on the extreme importance of procedural law. There is in one of his opinions the statement that he would rather live under a system of the Soviet law applied by American procedural methods rather than living under a system of American law using Soviet procedural methods. And a lot of the cases where, well, for one thing, he was the lawyer on the court, and so when cases came up involving procedure, very often he was the one who was assigned to writing the opinion. But he also was the one who was most likely to see a red flag when he thought that there was somebody who had been denied his procedural rights, and that was what he didn't like about the Japanese internment case. Nobody ever took these Japanese in and said, gave them a chance to show that they really weren't a menace, and that's bothered him. And it came up in several other cases during while I was there, and in other cases, and I think that was one of his hallmarks. A lot of that perhaps comes from Nuremberg, because he did comment that if you could just look as an abstract matter at the German substantive law, it wasn't all that bad. It was simply the manner in which it was applied that was so utterly reprehensible.
The opinion that he discussed, I think, the most during my first term with him was Irvine versus California. A very strange case where the police suspected these people of various illegal activities, and when they weren't home, police went and made a key to the front door, and then when the owners were away, they went into the house and put bugs all over the house, including in the bedroom, and then listened to the conversation thereafter for a sufficient period of time to gather evidence against them, and then convicted them on the basis, in part, of these overheard conversations. And when the case came up, Jackson wrote an opinion which in effect said, yes, this police conduct may have been illegal, but that is no reason to overturn an otherwise valid conviction, simply because the evidence, although true, was improperly obtained. And then he added a portion of the opinion which was joined by only one other person, and it said, because this may well have been a crime by the police, what we do in this case is not overturn the conviction, but rather have the clerk of this court send this opinion to the Attorney General of the United States and have him investigate as to whether a crime has been committed. Now, the only other person joining that was someone who had just joined the court, Earl Warren, who later would not have hesitated 20 seconds in reversing that conviction, but who was still sort of finding himself in those early days of his tenure.
And when Jackson would talk about Irvine, was
yes,
it with
because
pride,
he was
or?
he was obviously very disturbed by that case,
Right.
because there had been improper conduct. But at that point, at least, at that juncture, he was also disturbed about the idea that it wasn't that the evidence was untrue or it was otherwise tainted, it was simply that it had been improperly obtained. And why should you reverse an otherwise valid conviction for that reason? But we can't just let it stand there at that. I mean, if this was a crime, by God, let's go prosecute the police.
Which is the British system.
Yeah.
And this is somewhat pertinent to this. It's the interesting case of Stein against New York. This was before Miranda, and it involved some defendants who had not been Mirandized and had been held without counsel. They didn't have, and it was a felony murder case in New York. They really didn't have much of a defense. The only defense they had was they could show that they had bruises on their arms from which they couldn't take the stand because they had records a mile long. But they argued that, and they had confessed, but they argued that the bruises showed that they had been subject to police brutality, and that since they had been subject to police brutality, they should have been acquitted, regardless of what the other evidence might have shown. In the petition for certiorari, there was included, no, it wasn't, pardon me, it was in the record, not in the petition. The record showed that on summation to the jury, counsel for the defendant said, don't get upset about some crummy little murder. That's not important. The only thing that's really important is whether or not the police operated properly. It came up, the petition came up before I was there, and it was taken by Bill Rehnquist. And when he saw that, it waved a red flag, and he came rushing in to see Justice Jackson. And he'd read it all, and then he from then on, he was trying to persuade Justice Jackson that this is the ideal opportunity to prove, to have the court hold in these so-called coerced confession cases, that even if it is a coerced confession, if there's other evidence to convict the defendant, we should say that it's simply harmless error, as you say in all other kinds of litigated cases. Jackson was not willing to go quite that far. He went a long way in that direction, because he said that under the New York law, the final decider as to the voluntariness of a confession is the jury. And it is possible that the jury decided that the confession was voluntary and convicted him on that. It's also possible that the jury decided that the commission was coerced, but convicted him on the basis of other evidence. And even if that was the case, we're not going to say that the Constitution prohibits New York from that kind of a conclusion. That was as far as he was willing to go. Rehnquist himself, in later years, has come out in some of his concurring opinions with this notion to the effect that a coerced confession can be harmless error, and you can go ahead and convict on the basis of other evidence.
John, I see our time is running out. If you would allow me to just end on a personal recollection. There were so many delightful moments with the justice, but several I remember. A couple of times I would go out to his house in Virginia, which is, you all know, by Hickory Hill, because the house was later owned by Jack Kennedy and then Robert and Ethel Kennedy, and Ethel, in fact, still lives there today. But Justice Jackson owned that house, and we'd go out there and work sometimes. I remember sitting out on the back porch around a table, and the sun shining and the quiet there, and we would work, and then we'd branch off and start talking about fun things. And those were just really delightful days that I remember with a good deal of affection.
Well, that does help wrap this up. George, how would you summarize the significance for you of the experience of being a Jackson law clerk?
Well, it's hard to pinpoint any particular thing, but it gave me an appreciation of and respect for the law, which I carried with me, and he imbued me, I believe, with more or less his view of the law as the fabric which holds society together. And it just never left me, I'm sure.
What's the wrap-up thought each of you has about Jackson's significance? And to ask a compound question, you've described a type that I think we don't have much today on our Supreme Court or in our legal profession or in our public life generally. What does he stand for as a legacy, and have we lost something in a time where there aren't people like him?
He was a great man in my life and a model for me. He was a Renaissance man of many facets, and Lord knows I miss the writing. You just don't see that kind of writing today, and haven't for some time. The practicality of the man was imposing. He was wonderful.
Don, the legacy of Robert H. Jackson?
We do today. He was, at the time he was there, he was one of two justices who really had the necessary intellectual equipment to do the job. That is no longer a problem. We now have several justices who have, they're probably even good enough to be law clerks. But he had, in addition to this remarkable technical capability and this extraordinary knowledge that Barrett had referred to, he was a man who had his heart in the right place. He had good control of it. He didn't let himself go off the deep end emotionally, but he had a very keen sense of injustice, perhaps sharpened by his Nuremberg experience. And that was a combination that I don't think you see in anybody on the court today.
George, a final thought about the legacy of Robert Jackson?
Well, it would be that there hasn't been anybody come along with the experience that he had had. He was a man who, he was consumed by the law. That was his principal interest in life. And his legacy was one, as I mentioned before, was of respect for the law and pursuing it, and well, respect in the sense of recognizing that it's the fabric which holds, as I said, the fabric which holds society together. He was one of a kind. And I don't think we'll ever see another one quite like him, mostly because he didn't have the same people coming from the environment and the things that he did. They just don't make them like that anymore.
Well, I must say, not to inject a sad note, tomorrow, October 9th, marks the 49th anniversary of Justice Jackson's death. As we gain an increasing distance from a life like his, though, I think we gain a perspective on what he was, what he stood for, what he left us in his writing, what he accomplished in the law and for the world. And it helps tremendously to see the living legacy in the person of these three law clerks. I feel very privileged to have been a spectator on the side of this conversation, and I thank each of you for this conversation and generally for what you embody, which is part of the legacy of Robert H. Jackson. Thank you very much.
Thank you.
Oh, thank you. Thank you.
And we're already walking.